Hi, my name is Jeanette Hurst. I decided to write my book, Employment Tribunals UK, after representing myself at my own tribunal. This book will save you hours of time researching what you need to do. It's a step-by-step guide that explains procedures you need to adhere to, legal terminology, collation of evidence, preparation of your case, how to present your case, and what will happen at your tribunal hearing. You must be able to prove one of the following, so breach of contract, loss of mutual trust and confidence, or that you've been discriminated against. Do you have any of the below evidence that will prove your case? If you have no evidence, you have no case. But if you do and you want to represent yourself, you must download and fill out an ET1 form and send it to your local employment tribunal within 3 months of leaving your employment. Unfair dismissal is when your employer has dismissed you for no good reason, for example, employers not following the company's formal disciplinary or dismissal process. And constructive dismissal is when you're forced to leave your job against your will because of your employer's conduct. You need to have worked for the company for 12 months to claim. For example, the company doesn't pay you suddenly or demotes you for no reason, forces you to accept unreasonable changes to how you work, or lets another employee harass or bully you. You are protected under the Equalities Act 2010 from being discriminated against because of your age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex discrimination and sexual orientation. It's worth spending time filling out your ET1 form, as the Employment Tribunal read this document and decide whether to accept your claim and proceed. The Employment Tribunal then sends a copy of your ET1 form to your former employer, who need to respond to the Employment Tribunal within 28 days by filling out an ET3 form. You will receive a copy of the ET3 form and their grounds of resistance form, which states their side of the case. Take time to fill it out correctly. So Section 5, this is where you put the facts of your claim in a logical order. Section 6 is the remedy, so compensation, I'll go through this part later. And Section 7, use the blank sheet behind Section 7 to explain your case if you haven't had enough space to do this in Section 5. If the Employment Tribunal believes that you have a right for your case to be heard at tribunal, you will receive a letter with a date for the hearing and the case management orders. Can you prove breach of contract? So a contract of employment is a legally binding agreement between you and your employer. A breach of that contract happens when either you or your employer breaks one of the terms. For example, your employer doesn't pay your wages or you don't work the agreed hours. Terms of the contract, we have express terms and implied terms. Express terms are legally binding and cannot be argued against by either employer or employee. These may include pay hours holidays, disciplinary and grievance procedures, and in some cases a mobility clause. The law states that certain express terms must be put in writing and handed to an employee in the form of a written statement of particulars on or before they start work. Implied terms, these are more obvious terms to both parties regarding an employment contract. These include the duty not to destroy mutual trust and confidence and the employer's duty of care to its employee. The implied duty of trust and confidence applies to both the employer and the employee. Trust and confidence means that both parties trust each other such that they can have a functioning employment relationship. Any example of a breach of trust and confidence may be if an employee has been sexually harassed at work or demoted without cause. An employee can claim breach of trust and confidence in the employer because of the actions of another employee who the employer is responsible for. Other terms you need to be familiar with: claimant, you are the claimant, and respondent, your former employer is the respondent. Collate evidence in a folder, so every single piece of document that you believe will help prove your claim, stated early, for example, emails and letters. Your contract of employment, grievance and disciplinary procedure, your former employer's values and behaviours policy, your former employer's mission statement. Now download the following regulations, guidance, codes and add to your folder. So ACAS definition of employer's duty of care, ACAS guidance for employees booklet, bullying and harassment at work, ACAS Code of Practice 1, Disciplinary and Grievance Procedure, Health and Safety at Work Act, Protection from Harassment Act and Employment Rights Act. Look through your evidence and make notes. So your contract of employment, have any of the expressed terms been breached? Have you any evidence to prove loss of mutual trust and confidence? Does your contract state that the grievance and disciplinary procedure was an expressed term? If so, were you involved in either procedure and were these procedures adhered to? The ET3 form, grounds of resistance part, has your former employer stated anything false that you can disprove? Look at the statutory regulations and guidance that you've downloaded and make notes as to any parts that you think your former employer has contravened. Then look through letters, emails, memos and make notes on what they prove. If you have any questions that you want clarifying by a former colleague, email them and then print out their response. Remember, conversations can be denied, get email or witness statement evidence. Now photocopy each piece of evidence so you have 2 copies of everything. Master file will be for your original copies and a second folder for photocopied evidence. This second folder can be used to send to your former employer or their legal representative on the appropriate date. This is very important, as if any evidence gets lost, intentionally or otherwise, you still have your original copy. The remedy is the schedule of loss. Loss of earnings, pension contributions that you have incurred due to being dismissed by your former employer. You should be able to Google and download a remedy form from the internet, fill it out and send it by the date stated on your case management orders. Section 1, relevant details. You need to have these details to be able to fill out the rest of the form. And Section 2, basic award. To calculate this figure, visit the website shown on screen. Section 3, compensatory award. The second element of compensation is the compensatory award. This will be the amount that the tribunal consider fair in the circumstances. And the compensatory award is broken down into 3 subsections. The first, past losses, is the easiest to calculate and assess your financial loss from the date your employment ended with your previous employer until the date of the hearing. The second part, future losses, is to demonstrate to the tribunal that for a certain period following the hearing you will be unemployed. The length attached could typically range from 6 months to 2 years. Finally, there is a provision for the tribunal to make an adjustment to the compensatory award by awarding up to a 25% increase for the employer's failure to follow the ACAS Code of Practice on disciplinary and grievance procedures. Pension losses. The pension calculation section for the schedule of loss is particularly complicated. You can either calculate your losses as explained in the previous slide, but exclude the amount attributed to your pension, but make sure you state that this schedule does not include your pension's amount and you will be able to submit this part later. Collect the following information listed and include this in the schedule: accrued pension at date of resignation, annual pensionable pay, previous employer's pension contribution and contractual benefits if any. Do remember to include information about any money earned from a new employer if you are in new employment. Case management orders. So you need to send your former employer a list of documents that you wish to refer to at the hearing, and you need to prepare a full written statement of evidence that you or your witnesses intend to give at the hearing. The above needs sending to your former employer. So list of documents, make a list of every piece of evidence that you'll be sending to your former employer or their legal representative. so they need to have a date and a description. This list can be emailed to your former employer or their representative so that you have proof of exactly what you have sent. A paper copy can also be sent with the documents. The bundle is a copy of all your documents of evidence and all your former employer's documents of evidence. They are in paper format and each page is numbered. Please note your former employer will do this and send you a copy. All the evidence will be put in whatever order they see fit. This is a picture of my bundle. It consisted of 466 pages, but yours may be considerably less. This is the evidence for and against your case. You will rely on it at your tribunal hearing, and so will your former employer. The judges at the hearing will also have a copy of the bundle and will refer to it throughout the hearing as you try to prove your claim and your former employer tries to disprove it. So the first job is to check through the bundle by checking against your master file to ensure every piece of evidence is in there. If you have any evidence missing, then photocopy or scan the relevant sheets, then send them and ask for them to be put into the bundle. Now check through their evidence. Highlight any parts you think are important and attach a marker on the edge so that you can find it easily later. Make notes of the evidence in the bundle that you want to use to prove your case. In your notes, write the page number and paragraphs which are relevant. This will make it easy for you to prepare your written statement and the questions you intend to ask your former employer and their witnesses when you question them on the witness stand at your tribunal hearing. You need to send your former employer the name of your witnesses who will attend your tribunal, and you need your witnesses to have written statements that are true and are signed and dated. If you don't have any witnesses, don't worry. If you have enough provable evidence, you won't need any. You will be notified if your former employer is taking any witnesses to your tribunal. You will be given their names and copies of their witness statement. When you receive the witness statements, you need to carefully read through them and make notes of anything which is false and anything that will help your case. These statements will be numbered, and some of the numbered paragraphs may be split into sections. So in your notes, write the page number, section which you are claiming to be false. Preparing questions for your former employee and their witness that you'll question them on the witness stand. So you're going to need the bundle, respondents' witness statements, and the notes you've made so far referencing the bundle and written statements. Initial draft, make bullet points of the questions that you want to ask each witness. Make notes to state where the proof is in the bundle to counteract their answers or claims, and only ask questions which help your case and that you have evidence for. Be precise and succinct. Once you've completed these bullet points, formulate them into polite-sounding questions in a logical order. Write down the page number and paragraph of any evidence in the bundle that you wish them to refer to, and overleaf is how I set my questions out. I wrote my questions in black ink. I wrote the page number paragraph of any evidence in the bundle relating to the question in blue ink. In blue ink, I also wrote down what the evidence stated, so I didn't have to refer to the bundle myself. Any parts that I felt were most important to prove in my case, I wrote in red ink. This reminded me to speak the words that were in red ink slowly and with emphasis. The judges will make notes, and after you have completed your questions of the witness, the judge will then ask the witness further questions. This is how the judge follows and understands your case and later come to their conclusion in your favour or not. So your written statement is the most important statement you will do. The judges are given your written statement at the beginning of your hearing. They read your written statement, and this explains your case and directs them to the evidence in the bundle which proves your claims. Set it out as follows. So at the top you need your case number, your name versus the respondent's name, written statement, your name, and then your information should be set out in numbered paragraphs. State your claims against your former employer in a logical order and reference where you can prove this in the bundle. reference which statutory regulations they have contravened, and evidence identify where your proof is in the bundle, and state where in the bundle you can prove your contract of employment was breached and your mutual trust and confidence was broken. Finish your written statement with your closing statement. Your closing statement is where you sum up your claims against your previous employer. For reference, my written statement and closing statement are in my book The Underdog towards the end of chapter 8. You're now prepared. Check that you have the following: the bundle, your questions, a copy of your written statement and closing statement, and copies of your witness's written statement. This is what you'll be taking to your tribunal hearing. On the day of the hearing, arrive at the tribunal 20 to 30 minutes early and introduce yourself to the receptionist or steward. You will be taken to the claimant's room and the steward will ask you for a copy of your written statement, closing statement. The steward will later collect you and the respondent from your waiting rooms and escort you to the hearing room. You will be seated until the judge enters and you stand until they sit down. The judge will ask you what you are claiming. You could answer breach of contract and mutual loss of trust and confidence. The judge will read through your written and closing statement. You will then be questioned on the witness stand. Any witnesses you have will then be questioned. You will then question your former employer and any of their witnesses on the witness stand. The judge will ask any questions they think are relevant, and the judge will make their decision in your favour or not. If you win, you may have to go back onto the witness stand to answer questions about how you have attempted to find a new employer. The judge will award you an amount of compensation, and shortly afterwards you'll receive a judgment letter stating the amount of compensation you've been awarded and when you should expect to be paid. This book gives a more in-depth information on how to represent yourself at Employment Tribunal, and my book The Underdog explains other issues which can be encountered before and during your hearing. This is my own account of my 3-day tribunal hearing. Thank you.